Welcome to the 2017 Ohio Center for Law-Related Education Moot Court Competition. I'm Ann Yeager from Court News, Ohio. In a few minutes, two high school teams will argue a fictional case, State versus Matthews, before a panel of judges. Moot court simulates the appellate court process. Different from a trial, appellate courts have a panel of judges instead of a single judge and jury to decide the case. Appellate attorneys don't interview witnesses or present evidence. They argue their case based on witness written briefs and during oral arguments. State versus Matthews involves high school student Tracy Matthews. Tracy pleaded no contest to felony theft after posting pictures of Harrison High School's mascot, a stuffed honey badger, at various locations across Ohio. Tracy is challenging the trial court's decision to allow evidence taken from Tracy's smartphone, claiming school administrators performed an unconstitutional search and seizure. Tracy is asking the appellate court to rule that the school violated Tracy's Fourth Amendment right to be free from unreasonable searches and seizures, and that Tracy's consent to the search was not valid. Oral arguments are about to begin from room 101 of the Thomas J. Moyer Ohio Judicial Center here in downtown Columbus. As we wait, let's view some more details about the competition and the case.
All rise.
Please be seated.
Before we begin, I'd like to have the judges introduce themselves, starting at that end.
Hi, I'm Mike Hendershot. I work in part of the appeals section of the Ohio Attorney General's office.
I'm Tiffany Carwile. I work for the Constitutional Offices section of the Ohio Attorney General's.
Good afternoon. I'm Ben Tracy. I'm a staff attorney for the 10th District Court of Appeals.
Good afternoon. My name is Pat Fisher. I'm a justice of the Ohio Supreme Court.
I'm Sam Peterson. I work for the appeals section at the Ohio Attorney General's office.
Nikki Bazinski. I'm in the Appeals and Post-Conviction Division of the Ohio Public Defender.
Chris Walker. I'm a law professor at Ohio State University.
Thank you. The court will now hear arguments in case number H34567, Tracy Matthews versus State of Ohio. Your arguments, petitioner?
May I proceed?
Yes.
Good afternoon, Chief Justice Fisher, Associate Justices. May it please the court. I, Code M1, will be addressing the first issue of whether the trial court erred in ruling that the school did not violate Tracy Matthews' Fourth Amendment right to be free from unreasonable searches and seizures when they conducted an unlawful search of his phone's photograph metadata. My co-counsel will be addressing the second issue of consent. At this time, may I please reserve 2 minutes for a rebuttal, which I will be giving?
So reserved.
Thank you, Your Honor. We respectfully request that this court reverse the decision of the trial court and hold that the search of Tracy Matthews was unreasonable for the following two reasons. First, the search was not justified at its inception because the principal did not have an individualized suspicion that Tracy kidnapped Harry the Honey Badger. Second, the search was not reasonably related in scope to the circumstances justifying the search.
He did believe the Hooplas, or whoever they were, somebody of that group, correct?
Correct. He did have a hunch that it was someone from that group. However, a hunch is not enough to justify, or is not enough to meet that individualized suspicion that is critical in determining whether a search is reasonable under the Fourth Amendment.
But he was right.
When you have a hunch about something, you may end up being right, but a hunch does not meet that individualized suspicion that is necessary before conducting a search.
Is there actually a need for an individualized suspicion, though? I thought TLO specifically said that they were not deciding the individualized suspicion question.
Well, so you see cases like Vernonia and Earls where there are also, as TLO, is not an individualized suspicion. However, those cases are distinct, and actually in the case of TLO, they had a suspicion that it was one of just a couple people, one of a couple of the girls in the bathroom. However, this is a whole group of people we're talking about. It is not at all individual.
Was it more or less people than involved in Earls and Vernonia? I mean, those were all the extracurricular participants in the school.
Earls and Vernonia are very distinct cases because those actually did not require individualized suspicion because they implemented a special needs doctrine. That special needs doctrine essentially says that when you're the school's interest is the safety.
Isn't every search in a school a special needs search?
I'm sorry.
I'm sorry. Isn't every search in a school a special needs search?
No, because in the cases of Vernonia and Earls, those. A school's interest is keeping their students safe and healthy. And so in those cases, the school is conducting routine searches to prevent drugs from being in their extracurricular programs. This case is distinct because first, it was not a routine search, and second, the safety and well-being of the students was of no concern. There was no threat to that safety.
Counsel, couldn't there be some threat to the safety of the students? They had started to trespass onto people's property, and it was escalating, and so there could be safety concerns for whomever was the thief of the honey badger.
No, there wasn't a substantial safety concern because all of the tweets that were spread by whoever committed the crime were of a joking and a childish nature. There was nothing in those tweets to say that, oh, this person might pose a real threat to the students of Harrison High School.
I mean, the person that did the theft. I mean, they're trespassing now, and if you trespass onto the wrong property, you could easily get injured or worse. So isn't there a safety concern for the student that did the theft?
You know, we're talking about high school students, and we can actually see that because we don't use the initials of Tracy. We can assume that he's an upperclassman and not a minor. So we would have reason to believe that a student going onto another property wouldn't necessarily get hurt. There really wasn't any threat to the safety and health, the safety and health of the students. We can actually look to Gage, which is instructive. In that case, the students moved to suppress items found in a backpack, arguing that the school official did not have individualized suspicion that he violated any school policies. Finding that the trial court erred in denying the students' motion to suppress, the Supreme Court concluded that particularized suspicion is required in order to justify a search in its inception. Tracy's case is very similar to the case of Gage, as both searches lacked individualized suspicion. The school official, this being the principal, wasn't even certain that it was a student who committed this crime or that they were even from the school. It could have been someone from outside of the school. The principal had
Counsel,
a hunch.
Don't the facts kind of suggest otherwise? I mean, you said yourself a few minutes ago that these were things done for their comedic value. They stole something that's the inspiration for the school mascot. They planted it at one point in the principal's backyard in response to comments he made on a local news story. I mean, wouldn't that suggest to the reasonable person that a comedic group from within the school was responsible? And wouldn't that be individualized suspicion, at least as to each individual who's a member of that group?
No, because those actions would just justify someone having a hunch that a group or that particular group did that crime. So as I was saying,
Was that hunch reasonable?
the hunch may have been reasonable, but there was not enough suspicion, enough reasonable suspicion that the Harrison Hooplas committed this crime.
Go ahead.
How are you distinguishing between a hunch and suspicion? Where are you drawing that line?
So we can see in the case of Gage that in that case, they took a group of students from a certain smoking corner, and like the Harrison Hooplas, who were known for their comedic activities, the people from the smoking corner were known to be, do smoking activities, whatever that may imply. But the Gage court noted that the Fourth Amendment demands more than just a generalized probability, and a student's mere association with or presence among suspected wrongdoers without more does not provide a sufficient basis for a search by school officials. In this case, as was the case in Gage, the sweeping and indiscriminate search of only the students who happen to be in the same group ignores the need to ascertain individualized suspicion and exceeds the bounds of reasonableness.
Do we know how large this group was?
No, but the size does not matter because we can assume that in this high school it was more than just one student, or else it wouldn't be called a group.
How does this compare to the Beard case then?
The case of Beard was different because the school official who searched those students had reasonable suspicion to believe that the crime committed in that class and that the money was still in there. However, in this case, we have no idea when the crime was committed or where the person might be now, so that case is distinct in this matter. So, thus, like the student engaged, Tracy's motion to suppress should be granted. Moving to my second point.
Before you do, I just want to ask, you rely fairly heavily on Gage, but that was a decision of the New Mexico court. Is that am I remembering correctly?
Correct.
And so we're not obligated to follow that decision. That's not binding on us as a separate state, right?
It's not binding on us. However, we should look to these other cases that are so similar when we're trying to make this decision. We can't just decide, oh, we should do this. We have to look to these other cases to understand what we might need to do in this particular case.
Doesn't the U.S. Supreme Court say a couple of times that individualized suspicion might not be necessary, and so to follow a state case that says individualized suspicion is necessary seems to go against some of the U.S. Supreme Court cases, which would be binding.
You see in some of those Supreme Court cases where individualized suspicion is not required, and that those deal with the special needs that I was talking about earlier, where the safety and health of the students is at risk. And
Beard cites some of those cases, though, and Beard wasn't one involving the health and safety of students.
Yeah, so Beard, but as I said, Beard was distinct because they had reasonable suspicion to believe that the person who committed the crime was within the class and that the money would be found in that class.
So if we disagree with your position and think that the facts are sufficient to give the principal reasonable suspicion, then we could go ahead and find that it's okay based on, even though there is an individualized suspicion.
No, because even if there is individualized suspicion, we still must look to the scope of the search. So there's 3 points we must evaluate when looking at that scope. First, we must look at the student's legitimate expectation of privacy. Second, we must look at the intrusiveness of the search. And third, we need to look at the severity of the school's need to search.
Can I go back? I know I'm dragging you back to the first part a little bit. Can you show me where, I still have this impression that all school searches are under the special needs doctrine. Can you show me why that is? Where have I gone wrong on that? Where's the Supreme Court said otherwise?
I'm sorry, could you repeat that?
Sure. I guess my impression of TLO and the cases that follow from it is that school searches are themselves special needs exceptions to the Fourth Amendment. Can you point out where I'm mistaken in that?
So cases like TLO, they actually found that the search was reasonable because a school official actually saw the people committing the crime in the bathroom, and there was only a couple people.
Right, so that's a broader question, is that each of those 3 key Supreme Court cases that you're talking about, in each of them, the search was upheld. So where do I distinguish those, and what would you point me to rule in your favor?
So that all falls back to individualized suspicion. So we're saying that this is a group of students, the Harrison Hooplas, whereas they found 2 people in the bathroom. So if individualized suspicion doesn't necessarily mean that it's one specific individual, but it needs to be a small enough group.
And the Harrison Hooplas, a small extracurricular group, isn't out of the whole entire student body, isn't small enough?
No, well, we don't know how big the Harrison Hooplas is, but that doesn't necessarily matter. In this case, it's just not individualized enough, and that goes back to the case of Gage.
What number is then individualized enough?
It's difficult to establish a bright line. However, if you see 2 students, like in the case of TLO, smoking in a bathroom, and then you bring it to the principal, that's definitely more individualized than, say, suspecting that because there was a word in a tweet that these students committed some heinous crime.
So if there's only 3 Hooplas, that would be okay?
It may be more individualized, but in that hypothetical situation, possibly. But in this case, you can't. It's more individualized when there's less people involved. So first, the students at Harrison High School had an expectation of privacy. Now, while this expectation is lowered in a school environment, this does not extend to the school being able to search the photos and metadata on the phones. So this brings me to my second point, which is that the search was extremely intrusive. There was no particularized suspicion, and the principal searched photos and geotags of the student's phone. Now, these photos could have contained very private information, such as nudity or possibly memories that someone wants to keep private, such as the death of a passing grandmother. Not something they want to be seen by their principal or even the public.
Aren't drug tests pretty invasive? You can find out a lot of medical history with regard to drug tests and also illegal activity. So why was a drug test is okay, but searching a few photographs is not?
A drug test is different because you're not analyzing something that could seriously impact the student in the same way that photos can. So
say I have cancer and I don't want the student has cancer and doesn't want to know everyone to know that, and he's on medication for it. The drug test could come up with that information, and then they have that. So how is that different?
Well, in drug tests, generally, they're not broadcasted to an entire school body. Urine tests are generally kept between the people testing and the person themselves.
So these photos were broadcast to the whole entire student body?
Well, no, it was just the principal who saw those photos, but that still does not mean that the person, or Tracy Matthews, wanted the principal to see all these photos.
Does Petitioner concede that the principal is really searching for metadata and not for photos?
I'm sorry, can you repeat the question?
Do you concede that the principal was searching for metadata and not photos?
Well, we know that the principal was trying to find out who was at those locations mentioned in the fact pattern. However, we do not know for certain where this principal searched. So we do not know for certain that he just went through photos looking for metadata. He could have been looking, through all the photos. He could have gone outside of the photos, and that completely violates the terms of the consent waivers that the student signed. Third, the severity of the school's need to search was minor, as this was a case of theft. We see in cases like Beard and Kinsley, where there's a monetary theft, that the government found that the governmental interest was slight, and we should apply the same to this case, as it simply is a theft, regardless of whether, I see that my time has expired.
Finish it.
Sure. It served a less weighty governmental interest because this was simply a theft and not a serious risk to the safety and health of students.
Thank you,
For
Counsel.
these,
Thank you. Yeah, please.
Good afternoon, Chief Justice, Associate Justices, may it please the court. I, Code M2, along with my co-counsel M1, have the privilege of representing Tracy Matthews, the appellant. In my time before the court, I'll be addressing whether or not the consent to search given by Tracy Matthews was coerced, and whether the waivers were valid. We respectfully request that this court reverse the decision of the lower court for the following two reasons. First, Matthews was coerced to sign the waivers, therefore invalidating their ability to waive her Fourth Amendment right against unreasonable search and seizure. Second, the search conducted by the principal went beyond the scope of the documents, thus invalidating their ability to provide consent on the part of Tracy Matthews.
Tell me why you believe in that there was actual coercion.
Well, as established in Schneckloth, consent is required for a search to be constitutional if there's no probable cause and there's no warrant. Furthermore, the case articulates that it needs to be made out of a free and willful choice. It can't simply be out of compliance. The reason in today's case as to why it was coercive was because of the fact that many school officials, many teachers, were now turning to a more digital trend in the classroom where having a laptop and having a phone was necessary to truly engage in the educational merits of that class. The problem, however, is that if Tracy Matthews didn't sign the waivers in question, she wouldn't have been able to bring her laptop or phone to class, and therefore wouldn't have been able to participate, because the school...
Counsel, the school did provide laptops or other devices for the students, so it's not that she wouldn't have been able to participate.
Your Honor, the fact pattern is very clear on the issue that these loaners oftentimes were in extremely poor condition or unavailable. What that means is that whether not signing the form was not a viable alternative for Matthews because the school hadn't done their part to ensure that they had the proper...
Would it have been a viable alternative not to take pictures on your phone that you use for classroom purposes?
The point of the Fourth Amendment is not a question of content of what we own or the possessions we have. The point of the Fourth Amendment is to ensure that the government doesn't go past its reasonable scope and doesn't do unreasonable things to its constituents. What kind of pictures Tracy Matthews had on his phone is irrelevant in today's case and is a relevant question to the Fourth Amendment.
Well, is it irrelevant? Imagine it's a backpack and not a phone, and so you avoid the problem, like my colleague suggested, by not bringing those in your backpack to school and then not exposing them to possible searches.
The point of constitutional rights, however, is to ensure that we are protected from coercion and undue infiltration by the government.
Okay, so what if there was no coercion? Or what if there was a blanket policy that a device you bring into the school is subject to search?
Regardless of whether that policy existed, there still would be coercion so long as teachers, as are happening in the fact pattern we're looking at today, are using these devices in their classroom. And if the school still doesn't have...
How is there coercion if you make the choice beforehand not to bring those things into the school, whether it's by analogy, the pictures in your backpack, or by putting them on a device that you bring into the school?
Because she's coerced to bring these items into the school or not sign the waiver because of the fact that if she didn't bring them, she wouldn't be able to participate in the classroom.
No, but what we're talking about are the pictures, not the phone. She, or he, I guess, apparently, made the decision to take pictures on a phone and then bring that phone in. So consider the phone to be a backpack, as my colleague said. It's not the backpack bringing in. I might agree with you that he did not have an ability not to bring the phone in, but what about the pictures?
The point of a constitutional right against unreasonable search and seizure, as I mentioned earlier, is not a burden that we should place on the people who have that right. Rather, that's a constraint on the government. Whether I want to bring in a phone that contains, for example, incriminating evidence or incriminating data is irrelevant. I get to do with my property as I want as per the Constitution.
But that's not a consent issue anymore then. You're choosing to bring pictures that you do not need for any educational purpose at the school. Right?
Yes, however, that still doesn't justify the principal getting to search those phones because, once again, as I mentioned earlier, the consent by the individual and by Tracy Matthews was not at all by any means consensual and was simply made out of compliance. And the reason why, once again, is because there was no valid alternative because the school didn't have the means to to rectify her not bringing the phone.
Is your theory of coercion the same as to both waivers here, both consent forms?
It would apply to both waivers, yes. Furthermore, we can see that
How does it apply to the I'm going to call it the extracurricular waiver, which I imagine that's entirely voluntary to participate in those activities, right?
Yes.
I don't understand how your coercion theory that you've been explaining about the necessity of these devices for the classroom carries over to the extracurricular activities.
We have two responses to that. The first is that participation in extracurricular activities is a key part to getting your ability to get education in a high school. Being able to learn in high school, being able to participate in a high school is not just being about sitting in the classroom, it's your ability to do other things at school.
Counsel, didn't the court, though, say that to be able to participate in sports, that you had to consent to the drug test, and that was perfectly acceptable? So why is extracurricular activities get greater protection than sports activities, which have the same impact for college?
That's not a question of consent, or that's a question of the special needs doctrine, whether there was a serious governmental interest in preventing, for example, the cases you're referring, the drug abuse that was occurring at the school.
But if there wasn't coercion to require a drug test to participate in extracurricular, why is there coercion to say if you want to bring a device to an extracurricular, you have to sign this waiver?
Well, that's exactly the point. In Cumberlander, they ruled that a mandatory drug test was in fact unconstitutional because you either had to take the drug test or you were expelled from the school. And that exactly highlights the question you're bringing up, is that if you force someone to either engage in unconstitutional search or be expelled or highly damage your education in the school, then that is not constitutional by any means because it's a form of coercion.
Counsel, not participating in the Harrison hooplas is not the same as being expelled. I mean, there's a vast difference between expulsion from school and participation in a comedy club.
Two responses to that, Your Honor. The first is that while that is true to some extent, being able to participate in extracurriculars as a general principle, i.e. being able to do things after school, for example, maybe participating in the debate team under the same waiver you'd have to sign for the Harrison hooplas, would apply to the same principle. The school shouldn't be able to simply search your phone or not allow you to do any extracurricular activities.
Now, the extracurricular, you agree the extracurricular activity waiver has nothing to do with this case, right? Because this was not done during an extracurricular activity, the search was not.
Yes, it was done during school hours, which once again goes back to your question insofar as the fact that this occurred during school hours, once again reemphasizes the fact that under the first waiver, she could not functionally participate in the school environment because she had signed that, and if she hadn't, she wouldn't be able to engage in the classroom activities. Furthermore, the court
Does the extracurricular waiver limit the search to occur during the extracurricular?
Yes, it does. The one that would apply specifically to something happening during school hours would be, in fact, the first waiver. Furthermore, the court has ruled that we need to look at a totality of the circumstances test when looking as to whether there is coercion present beyond, for example, the theory I'm presenting regarding the laptop. For example, in Haley versus Ohio, the court ruled that we need to take into account the age of the accused, and in Payne versus Arkansas, we must look at the education of the accused in determining whether coercion was present. The fact that, once again, this was a young high school student who was addressed by an authoritative figure to give her phone clearly indicates there was some level of coercion.
Counsel, your co-counsel said that this was not a minor, so an 18-year-old. It's supposedly a senior, so they've almost finished their high school education. So we're not talking necessarily about a young minor here. So why can't an adult understand the waiver?
18 being legally considered an adult is in a sense an arbitrary bright line insofar as the fact there's different level of maturity between an 18-year-old in high school and a 22-year-old in college.
Yes, but they both could be convicted of murder and go to jail for the same amount of years.
Yes, but once again, the court requires a totality of the circumstances test, and the fact that this individual was in high school and wouldn't be completely aware of all of their constitutional right contributes to the idea that there was still a level of coercion present. Furthermore, with regards to the second point, the school search of Matthews' phones violated the waivers signed by Matthews. The waivers mandated three important things. The first, that the school had to have a reasonable, articulable suspicion. Second, the school had to give notice to Matthews that the search was taking place. And third, the school needed to give Matthews, or alert the student that they had the right to refuse the search.
Now, it seems like you're relying fairly heavily, and I think you've even said, on the waiver requiring bringing a device to school. And let's say we disagree with you, and we think that the extracurricular waiver is also in play. How does that affect your argument?
Your Honor, under both waivers, the principal violated the terms of both of them. Whether you believe the extracurricular is more important or the general one is more important, the principal violated both of them, and I can get to that now. With regards to the general waiver, the principal violated in two ways. First, there wasn't an individualized or articulable suspicion. As co-counsel brought up, it was simply the mere association of a word that led him to search these individuals' phone. Then second, the school never told Matthews he had the right to refuse, which was indicated in the general waiver that they had to do.
Don't they tell the school by having the waiver there and having it written down that they have the right to refuse? He read it presumably before he signed it, so he knows he has the right. Why isn't that sufficient?
The reason why the provision was in the waiver in the first place is that we have a lot of constitutional rights, and sometimes we can forget some of them. She signed that right at the very beginning, she signed that contract at the very beginning of the school year. The reason why that provision was in the waiver in the first place was to indicate to her and to remind to her that, yeah, she did have this legal provision to warn her that she had a right to refuse.
But it's not a constitutional requirement to tell someone that they have the right to refuse consent, is it?
It's not a constitutional requirement, but the reason why that provision was in the waiver and why the fact that it was violated many months later when the principal searched her phone is still relevant is because oftentimes you can forget that when you sign these kinds of contracts, you forget about these legal provisions that are supposed to help you.
If the principal had, when he gathered this group together, looked at them and followed what he was supposed to do under that provision and said, you have the right to refuse, would that have changed anything?
It would also have to have a more articulable and reasonable solution,
But would it have changed anything?
It would have helped their case, but it would not have been sufficient. Furthermore, to answer your question, the extracurricular waiver was also violated by the principal in two ways. The first was that it only applies to internet search or internet browser data. What this means is that the internet or the extracurricular activity waiver only applied to searching the individual's phone and searching their web browser history, which was not done by the principal. He browsed through his phone and browsed through his metadata, which you can't simply
Where
get
does
off the
it
web
say
browser.
that? Where does this waiver say that it's limited in that way? It says right in the middle of it, I understand my child's device may be subject to search and seizure. That seems fairly broad.
The reason why that clause applies to the extracurricular activity waiver is because when the principal was referring to the policies set forth in the handbook regarding these kinds of extracurricular search and seizures, he referenced that the only way they can actually conduct these searches is by looking at the phone browser data. So that was not in the text verbatim of the waiver that he signed. It was implied when he read and signed the handbook. But the second way in which the extracurricular activity waiver was violated, once again, if you don't buy that argument, was that it only could be searched during during the hours of the meetings. However, when the search conducted that is relevant to today's case, that occurred during a school day, not during.
Where does it say that?
That's the one referring specifically to the extracurricular activity waivers says the search may only take place during a meeting of this extracurricular group. So the fact that that didn't occur, once again, shows that the principal was in violation of these waivers. Furthermore, the violation of these waivers in contract has constitutional implications for two important reasons. The first is that when you sign a waiver, the only way opposing counsel can actually generate a level of consent given by Matthews is if they reference the waivers. The fact that these waivers were broken by the principal indicates that we can't look to it as a level of consent, because Tracy, in a sense, had a form of qualified consent. She said, I only consent to the search when she signed the waivers if the principal was consistent with his end of the bargain. However, as I've showed on many different occasions, he wasn't. So,
Counsel, what about just an implied consent? If a police officer comes up to me and says, I want to search your backpack, hand it over, I don't have to, but if I hand it over, I've consented to the search. The principal asks for the cell phone, is given the cell phone. Hasn't Mr. Matthews consented to the search?
That's why Schneckloff is instructed to us for a few reasons. The first, as I mentioned, was that this was only a high school student, unaware of their constitutional rights compared to, for example, a 30-year-old who might be stopped by a police officer. Also, we have to look at the age of the accused. Now, I'll completely agree she's an 18-year-old. However, an 18-year-old is a different person than a 30-year-old who, once again, gets stopped by the police. We have to look at the fact that...
But they're both subject to the same criminal laws at age 18 as they are at 30, right?
Whether they're put to the same criminal laws is irrelevant to this question, because what matters is whether or not a level of coercion under a totality of the circumstances test was more applicable on the 18-year-old or on the 30-year-old.
Was there anything like the expulsion in the district court case that you cite, any kind of coercion like that going on when these students were brought into the principal's office? Was there anything beyond just, I'm asking to search your cell phones?
So there's a few, as I was mentioning, it's the age of the accused, the fact that it was only in high school, but also the fact that it was alone in a principal's office. This authoritative figure comes up to you and tells you to give them your phone. As an individual in high school, it's very hard for you to refuse that kind of search. And that further adds to the fact that it wasn't simply tacit consent. She had to do this or she feared the alternative. Furthermore, the fact that she was functionally coerced into signing these waivers in the first place.
What would be the alternative, counsel, that she was scared of?
She might be, for example, scared of getting into more disciplinary trouble. She might be scared of the principal not letting her leave. She might be scared of the principal.
Is there any evidence of that on the record?
There's no evidence of that on the record, but that's not necessary. When looking at analysis of a totality of the circumstances test, when looking at whether an individual felt coerced by an authoritative figure, and not everything needs to be backed up by evidence in the facts. We can look at.
So wait, you're just asking me to assume that there was coercion there, or there's nothing there that's from the principal end, you say, that supports coercion. You're asking me just to speculate that was there?
Respectfully, Your Honor, that's not what I said. I said that looking at a totality of the circumstances test, we can look at the fact she was in high school, the fact that she was a student, and the fact that in a student, she might fear the possible outcomes of, for example, Your Honor, I see my time has expired. May I briefly conclude?
Yes.
She might be concerned of the possible outcomes that might occur if she, for example, denies the principal's motion. We respectfully request that this court overturn the decision of the lower court and grant Tracy Matthews' motion to suppress. Thank you.
Respondents?
Yes, Your Honor. Before my time begins, I would like to confirm that my student code is H3. Along with my co-counsel, we represent the respondent in today's case. I will be addressing issue 1, and my co-counsel will be addressing issue 2. Mr. Chief Justice, may it please the court. There are 2 issues before this court today. The first is whether or not the search violated the petitioner's Fourth Amendment rights, and the second is whether or not the petitioner gave voluntary consent for the search to be conducted. In looking at a search conducted in a school setting, we must look at 2 factors set forth by the United States Supreme Court in New Jersey v. TLO. The first factor is whether or not the search was based on at its inception, and the second is whether or not the search was reasonable in scope. In looking at the inception, a search is reasonable at its inception when a person has a reasonable belief that a search would turn up evidence that a person has broken a school rule or law.
So would it be okay to search everybody in the school, 1,700 kids or whatever, how many kids, every one of their cell phones?
No, Your Honor, it would not. And that is because there would be no reasonable basis for a search to be conducted. Further, students enter into school voluntarily, and it would be coerced for a school to say that they are obligated to be searched.
Okay, well then, tell me what was the basis for the reasonable suspicion that it was the Hoopla group?
Here, there was reasonable suspicion because of the word hoopla, which was associated with the group, in addition to the fact that this group had been known for pulling pranks in school, had a disciplinary record from the previous year, and the fact that the juvenile nature of the tweets led the principal to believe that it was a student who had stolen the mascot.
Counsel, doesn't the disciplinary action, that involved posters and not following school rules with regard to the posters. Now we've moved on to theft and trespass. Those seem vastly different to me. How would those even connect together to give suspicion to the principal?
Your Honor, they would connect because students would, the nature of the tweet suggests that the student had stolen the prank because he thought it was funny. Just like in the previous years where they had made the posters with inappropriate language because they thought it was funny. That's why the principal was able to rely on this factor.
Wasn't stealing mascots sort of a time-honored high school tradition or something? Why do I think I should focus on the comedy group instead of somebody else?
Because of the word hooplas, which had associated the comedy group with the theft. Because the comedy group's name is Hoopla's Comedy Club, in addition to their history for discipline and in addition to their reputation for pulling pranks.
Do you concede that that there's not a special needs search here? That we do need to have some type of reasonable suspicion?
Yes, Your Honor, we do need reasonable suspicion, and we have it. There was reasonable suspicion that someone in the Hoopla's Comedy Club had committed the theft.
Why
So
don't
I
you
guess
need-
that gets to the,
Go ahead.
it gets to the question that we asked the opposing counsel then. How many people is too large for it to not be an individualized reasonable suspicion?
Your Honor, we have to look at the totality of the circumstances. And when looking at the totality of the circumstances, the number of people must be taken into account. But the Hoopless Comedy Club, there's nothing in the record to suggest that it is so large that it would not warrant this search. In addition, Chief Justice Fisher recognized on opposing counsel's argument that the principal did believe that the Hoopless Comedy Club
So
was
instead, if the
associated with
Twitter, if the tweet said, "Go Badgers," would that be enough to do a search of every student of the school? Because now every student of the school has been identified as a Badger, as their, part of their school pride.
No, Your Honor, it would not, because that is the entire population of the school, and a school is not at liberty to search an entire population.
So how small of a group would it have to be in order to have individualized suspicion, not just everyone? At some point, you've got to draw a number or a range here. How is this individualized?
It would depend on the other factors. If there was an extremely large group, there would have to be extreme evidence that would suggest that a person in that group had committed the crime.
We don't know how large the Hooplas is, correct?
That's correct.
So it could be an extremely large group.
Yes, that's correct.
So how does this differ from the Gage case that the petitioners raised, or are you saying we shouldn't follow Gage, the New Mexico case?
I'm saying we should not follow Gage, and more than just because of the fact that it's persuasive. We should not follow Gage because in that case, the search was based on association, and that association alone. Here, it's more than just association. We cannot look at this simply as in Gage, where a search was conducted associating smoking with a group of students, with this case, because this case had more than just the association with the word hoopla. It had the history of pranks, it had the disciplinary record, and it had the juvenile nature.
But it sounds like you're asking us to target groups of students who in the past have gotten in trouble, and so when something bad happens, that's who we look to first. Isn't that problematic?
Your Honor, we have to take that in account along with all of the other factors.
So if you've committed some sort of disciplinary infraction in the past, for as long as you're in that school, you're the first one that we'll look to and the first one that we'll search? You're the first person whose rights we're going to violate?
Not necessarily, Your Honor. One, because searches weren't violated here, and two, because if you have a student that had potentially been drug dealing, the odds of you searching them for stealing a phone from a person are lower, although probable.
Has this group ever been accused, any of the groups been accused of theft in the past?
No, Your Honor, however, they had...
So what's the similarity between their prior transgressions and the acts that they're being alleged of having done here?
Because the nature of the tweets suggested that a student was placing it in the principal's pool and placing it at a flea market and placing it at the...
It's in the principal's pool. Does the school have a swim team? Do we look at the swim team? If the Badger had been, at a chess club or being photographed with chess pieces, do we look to the chess club? Football? I mean, it's a pretty tenuous connection using a word in a tweet to say that the Hoopla's extracurricular club and everyone involved in it now is subject to searches.
No, Your Honor, and that's because the Badger was not placed in the pool to show that because there was water, they must automatically be associated with the swim team. The reason this search was conducted is because of more than just the word hoopla, in addition to the fact that something being placed in a pool cannot just simply mean the swim team. But the fact that it was placed in the pool goes to the governmental interest here, as set forth by Vernonia v. Acton by the U.S. Supreme Court, which said that we must look at the governmental interest.
What was the governmental interest here?
The governmental interest was high, Your Honor, and this is
What was it? Not it's high-low. What was the governmental interest?
to ensure the safety and education of the students in the school.
How does
The education?
Yes.
How did it further that? I understand the safety of the honey badger, I guess, or the property, but how is it the education furthered?
Your Honor, it wasn't furthered. The act of stealing this mascot infringed upon the education that must be protected in the school.
How?
So much commotion was surrounding these tweets that the principal felt he had to move forward and conduct a search. He felt that in conjunction with the fact that the student who had stolen the honey badger went as far as to trespass on the principal's
This gets back to my original question about special needs then. So you are making an argument that this search was necessary for the health and safety, the educational value of the school.
Yes.
Is that in the record? The principal said, I'm doing this search because I'm worried that the educational environment of the school is being disrupted by this ongoing prank.
Those words aren't explicitly in the record because we have to look at the totality of the circumstances.
Because I view this much more as the principal playing police detective trying to solve a criminal, theft, and particularly offended because there was a trespass on his property that has nothing to do with him managing a school, but more to do with him feeling violated as a person outside his school. This looks a lot more to me like a police activity, not a school activity. Is that a fair assessment of the case?
I don't believe so, Your Honor. And this is because of more than just the fact that the principal's private property had been trespassed on. In addition to that fact, which threatens the privacy of the principal himself, which can go to his ability to complete his job, also coupled with the fact that this mascot was worth over $63,000 and was viewed as an invaluable item to the school for going on 6 weeks after the first time this was stolen. There had been multiple tweets that had just become...
I agree that your artifact is significant and pricey, but how does that fact that it's a valuable artifact go to the health of the students, the safety of the students, the education of the students? It didn't seem like there's anything in the record that the commotion is in messing up classroom time or causing a disturbance during teachers' lectures. There's nothing in the record to that. So how does it go to education and safety of students?
Your Honor, the commotion surrounding it did disrupt the education that was supposed to be secured for the students. By more and more commotion that you recognize on opposing counsel's argument was continuously escalating, there was an infringement on the education of the students.
So what is in the record that we can point to see evidence of that commotion disrupting classroom learning, for example?
It is in the record that the tweets were becoming more and more popular with students, that students were saving all of the pictures and talking about them in all of their classes.
I want to move on to the breadth of this search, that second prong that you mentioned at the outset. Would you agree that searching an individual's pictures, and especially metadata that includes where they've been, is an extremely invasive search into one's privacy?
I would not agree, Your Honor. And this is because the privacy interest here is not such as an unclothed body, a person's personal bedroom, their persons. It is simply the photographs. It isn't even the text.
Couldn't all of those things be photographs? I mean, if you're saying that those would constitute significant infringes on one's privacy, then a picture of any of them that's contained in the phone would also be an infringement in privacy, right?
Also, counsel, before you answer that, doesn't the Fourth Amendment specifically list a person's papers, i.e. their documents, things which may be contained on a phone?
Yes, Your Honor. While there is
I don't think this is a serious invasion of privacy.
I don't, Your Honor. While there is a privacy interest here, it is not so high that it wouldn't warrant this search. In fact, the U.S. Supreme Court recognized in United States v. Drayton that this search must be looked at with a reasonable innocent person test, which means that we cannot look at the search, as opposing counsel brought up, as a phone with pictures of nudity or drugs.
Well, I don't even think about nudity. I think about the fact that you'll now know where I've been with the metadata. These students are going places, are doing things that are completely innocent but very personal, like going to church. Maybe these students are going to church every night in a very personal relationship with their divinity. And the principal is establishing and understanding this by being able to look at the metadata and seeing where they go. Is that not a serious invasion of privacy? To me, that strikes me as much more, in some ways, much more invasive than even a strip search like we had in Beard.
Your Honor, while there is an expectation of privacy, it is not so high that it wouldn't warrant a search. Here,
Is there anything to suggest that the search of the phones was limited to a date range or anything like that? Or what do we know about how much of the phone was searched, how much of the data?
while the record does not explicitly say what metadata was searched of each photo, there's nothing to suggest that the metadata of only the photos that had been posted on Twitter was searched. There's nothing to suggest that the photos that weren't on Twitter weren't searched.
Counsel, I'm not wanting to go into the validity of the consent forms, but does the fact that consent forms for searching had been signed play into the reasonableness and the privacy interest of the student?
Your Honor, those consent forms must be looked at as mutually exclusive of the Fourth Amendment issue. However,
So it doesn't, you're saying it doesn't inform our decision of whether he had a reasonable expectation of privacy because he had signed them or hadn't signed them?
Your Honor, the policies on the form do show that a student is subjecting to a search of their phone. And so then, yes, I do agree they would have a lesser expectation of privacy because they signed those consent forms. In addition, the U.S. Supreme Court recognized in Vernonia v. Acton that a principal or school official does not have to choose the lesser intrusive method of conducting a search as long as the method is reasonable.
Well, it has to be reasonably related to what they were looking for. I don't think you answered the question. Do we know from this record that the principal didn't look at all of the photos on the phone, that search actually was limited to just pictures of Harry?
There's nothing on the record to indicate explicitly what that was.
Doesn't the record indicate that he looked at other pictures that the student took around the same time to confirm that that was the student that took the pictures? I mean, he looked at the metadata of all the pictures around the same time to confirm that that same student was at those different places where the photos were taken. Isn't that right?
I see my time have concluded. May I finish your question?
I guess I look to the
Yes,
chief.
yes. Proceed.
There's nothing in the record to indicate that he looked at the metadata of every single photo. But therefore, the search was constitutional and did not violate the petitioner's Fourth Amendment rights. Thank you.
Thank you, counsel.
May I proceed?
Yes.
Before my time begins, I would like to confirm that my student code is H4, and I am addressing question 2 for the respondent. Chief Justice Fisher, may it please the court. The second issue before the court today is whether the petitioner voluntarily consented to the search of their cell phone. It is our position that because the consent was voluntarily obtained due to the signing of 2 consent forms, the search did not violate the petitioner's Fourth Amendment rights.
Does the extracurricular form matter?
Yes, Your Honor.
Why?
The extracurricular form indicates that Matthews not once but twice agreed and consented to a search of his device. And
Do you read that extracurricular form, and similar to the question I asked your friends over here, does it extend to searches outside of extracurricular activities?
Yes,
Is that your position?
Your Honor, because Matthews chose to participate in the after-school comedy club called the Hooplas, he signed the extracurricular student
Right,
device
but does that
policy.
in your view, does that waiver on that form extend to searches that are plainly during regular school hours?
Yes, Your Honor, it does, because this form was specifically for students who wanted to participate in these extracurricular activities, and the search of Matthews took place because he was part of the Hooplas, and therefore the second form does apply to the search in today's case.
Your opposing counsel, I believe you probably heard, told us that the extracurricular search form only allowed the device to be searched during extracurricular activities. Do you disagree?
Yes, Your Honor, I do disagree, because the form states that the form applies to children's extracurricular, to their devices for extracurricular purposes. And this applies to searches beyond just ones in the time after school.
How does the time during school, though, that the club was pulled in relate to the extracurricular activity of the hooplas?
Well, because the fact that Matthews was a part of the hooplas and he signed that form, and the search took place because the principal was searching the hooplas, the second form applies because he identified himself with this group and he signed this form.
What extracurricular activity were they participating in at that time such that the form is operable?
Your Honor, the record does not indicate what they were doing at the specific time.
So we don't have any evidence that they were engaging in extracurricular activities when they were searched.
Your Honor, the record does not indicate that. However, the students were a part of this group, and because they signed these forms and because the search was pursuant to the fact that they were in this group, this form does apply.
So, but
in addition,
didn't the lower courts, find that form only allows? I mean, the form itself is so confusing, but the lower court said that the form only applies to searching their internet, their web data, and not, it doesn't say anything about pictures or metadata, right?
well, Your Honor, the principal testified to that at the trial during the lower court decision. But within the specific policy, the limitations to the browser history are not included within the specific document.
But the principal's already conceded this at trial then, right? That he only had the authority under that form to look at the website history.
Yes, Your Honor. And that is why, in today's case, the first form applies as well.
I want to talk a little bit about this first form. Opposing counsel seems to suggest that you would never be able to create a policy, a consent form, to search cell phones if they have to be used for educational purposes. And I kind of wonder, is there a way after this case, if we rule for the other side, for a school to come back and actually be able to search phones as part of their educational program?
Well, Your Honor, in this case, contrary to what opposing counsel stated, students are not being denied of their education if they choose not to bring their phones to school with them.
How do you know that?
Because the school provides additional devices, such as loaner devices.
Said that those aren't really viable alternatives. Like, in all actuality, there isn't an option. You have to bring your device.
Well, the record indicates that the quantities were limited and they may be out of date, but because the main purpose of these devices were to download textbooks and to complete assignments, the software wouldn't be so out of date that the students wouldn't be able to perform these basic tasks.
But if the devices, if say they're all being used, I mean, aren't you harmed without being able to download a textbook?
Well, Your Honor, if the devices aren't all being used, the teacher would, in that situation, possibly provide a hard copy of the textbook in that situation. But the record does make it clear that schools are making an effort to provide additional resources to students.
So I guess to kind of follow up on that, so if we adopt opposing counsel's view that a child cannot make a reasonable choice under the current circumstances, the school's only alternative would be to have to spend lots of money to buy additional devices and to continue to replace them so that they're at the same level as the ones that the kids are bringing. Is that?
Or the schools could transition to more of a inclusive policy where students can use paper copies of the work being done in class.
Or they could not give up their right to be, not unreasonably searched by their school officials.
Well, Your Honor, in this case, Matthews would not be significantly deprived of any educational opportunities, and the school is merely protecting the students who choose to bring their devices to school and the teachers who choose to use those devices in classes. So this policy is necessary to ensure that students are following the guidelines of the school and protecting the safety of the students within the educational environment.
Excuse me, is your position that the principal searched in accordance with the policies, or do you concede that his searches were violative of those policies?
Your Honor, within the document, there are certain guidelines that are stated when an official is conducting a search, and the principal did not follow all of these guidelines. However, these technical deviations on the principal's part does not neglect the fact that Matthews signed these forms himself, and
Didn't he signed those forms with the understanding that the guidelines would be followed, though? So if the guidelines weren't followed, then his initial consent wouldn't be valid.
Your Honor, the principal did not inform the student, or Matthews, that he had the right to refuse the search, but Matthews was aware of his right to refuse the search because according to S.V. Drayton, when looking at the facts of today's case, we must apply a reasonable innocent person standard. And a reasonable person, when they read a policy, reads the provisions of the policy and understands the form before they signed it. So
I characterize your friends on the other side as adopting sort of a contract theory of this first waiver. The principal didn't follow through on some of the things that are in this policy. And it sounds like you agree he didn't follow them strictly. So are they right or wrong that this consent should be looked at as a contract? And if they're wrong, where do I find that?
Your Honor, opposing counsel has stated that because the principal did not advise the student of their right to refuse the search, then Matthews did not consent to the search and Matthews was not aware of his right. However, the form specifically states that when the student signs the form, they are aware of their right to refuse the search.
Counsel, I don't think that's quite the answer to the question. It was, is this a contract, like a contract? And if it's like a contract, if the first party doesn't meet their obligations, but most of the time the second party doesn't have to meet their obligations. So if the principal didn't meet his, why is Matthew still bound by the contract? Or do you disagree that this is a contract?
Your Honor, I disagree that this is a contract because this form is simply a statement acknowledging the student's right and laying out the basic procedures for a search. And I concede that not every single procedure stated within this document were followed, but that does not...
So I want to get back to this idea that it's a technicality. It's been a while since I was in high school, but if I were called into the principal's office, I'd be scared to death. And if the first thing the principal says is, turn over your phone so I can search your metadata and your pictures, I'm going to be scared. Now, if what the first thing the principal said was, as according to he should have under the policy, you have a right to refuse to turn over your phone, but please turn over your phone, I would not turn over my phone if I were in the position. So it's not a technicality to me, and this is like the case, his failure to provide the consent, to provide the warning that you didn't have to turn over the phone.
Well, Your Honor, when applying the test set forth in Drayton of a reasonable innocent person would not feel any hesitation to turn over a phone if it didn't have any incriminating...
What if it had sensitive things on? I mean, do you disagree with several of the questions here that suggest the pictures I have on my phone and the locations I have traveled with it may well reveal things far more sensitive than just the evidence of crime?
Yes, Your Honor, there may be sensitive information on the phone. However, going back to the form, Matthews knew that if there was sensitive information on the phone that he didn't want the principal to see, he had every right to refuse the principal before conducting the search. And the record clearly indicates that before the search took place, Matthews did not object to the search. He did not ask the principal why.
Do you agree, though, that it's a really intimidating experience to be called into the principal's office and be asked to turn over your personal phone?
Well, Your Honor, if the principal did not search the phone in today's case, it would be a law enforcement officer. And the respondent submits that a law enforcement officer is significantly more intimidating than a school principal because students see their school principals...
You're suggesting that if the police had come down and conducted this search, we'd look at this the same way?
No, Your Honor. I'm saying that even though the principal is an authoritative figure, they're less authoritative than law enforcement because students often see their principals on a day-to-day basis. They may even have relationships or conversations with the principal prior to the search, which indicates that the authoritative presence of a principal would be less than that.
So are you saying it was reasonable for the student to expect that they actually had the right to refuse the principal's order to turn over your phone so I could search it, even given the fact that it's in the policy that the principal is going to warn them that they have that right, and then the principal fails to warn them that they have that right? You're saying they still should have reasonably expected that they had that right and that that would be honored?
Yes, Your Honor, because a reasonable person who signed these forms would know that they have the right to withhold consent to the search, because that is what is stated specifically within the document. It says, I understand that I have the right to withhold my consent to the search.
Right, but the principal doesn't follow the document, so why should the student expect that the principal is going to honor their refusal if they attempt to refuse?
Well, Your Honor, even if the student is unsure of whether the principal will honor their request, they should at least make an attempt to request. Unlike Matthews in this case, who didn't even ask why his phone was being taken, or even ask what it was being searched for.
Counsel, say we disagree with you about the forms, and we think that neither form is applicable in this case. Was there still consent by Matthews turning over the phone to the principal?
Yes, Your Honor, because one key fact that needs to be looked at is that cellular devices these days are normally protected with a passcode. And this shows that when Matthews turned over his phone to the principal, he put in the password.
Is there any evidence of that?
No, Your Honor, and an alternative to that would be that Matthews didn't have a passcode on his phone, which lowers his expectation of privacy, knowing that if he were to leave his phone somewhere, anyone could open it and look at its contents.
That doesn't go to consent, does it? That might go to your co-counsel's point about reasonableness, but that wouldn't help your consent argument.
Yes, but Matthews did consent to the search today because he did not ask as to why his phone was being taken or even question what the principal was doing with it or refuse consent.
Yeah. Let's say I disagree with you on the in-school policy. The principal didn't comply, and so therefore the waiver was invalid. I want to take you back to the extracurricular waiver, and you answered Justice Walker's question to say, well, the principal testified that there were limitations, but I believe Justice Hendershot had asked, where in the text. So let's say the principal's understanding of the limitations are different than the understanding on the limitations actually imposed in the waiver. Which one is the one that is relevant for us today when answering your question?
Your Honor, both of them apply in today's case. Because the search took place during school hours, the first form could be used, and because Matthews...
I think, if I may be so bold as to tack on to Justice Peterson's question, I think he was asking if the principal's understanding of the scope of the second waiver differed from what the second waiver itself said, which one controls as to the validity of that waiver and its scope?
Well, Your Honor, that depends on where the principal's assumptions of the additional provision stated within the second document comes from. The record does not indicate where that is. Maybe it's within the school policy.
I'm sorry to ping pong. You have a different question that I see as the time is running out here. So in the first waiver, it says that a device may be searched if the official has a reasonable articulable suspicion. So does the waiver do much here if it has that sort of built-in legal standard?
Yes, Your Honor. May I finish your question?
Yes, go ahead.
Yes, Your Honor, because within this document, I'm sorry, could you repeat your question?
Sure. I'm just wondering, what does this waiver do if it has a built-in legal standard of articulable suspicion?
Your Honor, it indicates that the principal would need to have a basis for searching the student's phone rather than randomly approaching a student and asking to search their phone pursuant to the policy without any grounds to do so.
Thank you.
Thank you.
2 minutes, I believe?
May I proceed?
Yes.
May it please the court. 2 points on rebuttal. First, opposing counsel does not establish that there was any sort of individualized suspicion. As you mentioned, Your Honor, there are many other parts of the photos that could have suggested...
Keep saying individualized suspicion, but where is that coming from? Is that in TLO, or where does the individualized suspicion come from?
Well, when understanding the totality of the circumstances, if you're just pick a group of people and say, oh, I think one of you did it maybe, that's just a hunch and that does not justify a search. But as you mentioned, Your Honor, there are pictures near a pool. There are pictures outside the Rock Hall. It could have been the band. There were pictures of them about to sell Harry, or could have been an investment club. But because the principal the principal chose the hooplas to look at out of all of these groups. And the
What's your response then to your opponent's argument that it wasn't just based on the hoopla language, it was based on past conduct? Can that be used to identify reasonable suspicion?
Because they were pretty funny. I mean, the tweets were funny.
correct, but it
I would
doesn't.
assume it's a funny group that's doing the
Not the
doing
investment
activities.
club.
Correct, but my opposing counsel essentially said that they thought that these posters were funny, and so they did this crime because they thought it was funny.
Not that they did it, but that they had a reasonable suspicion to think that they did it, right? I mean, not even probable cause, just reasonable suspicion.
But just thinking that
It's a very low bar.
just the assertion that two events are funny does not justify one particular group meaning doing both of those things. Second, the opposing counsel contends that privacy interest is slight. Your Honor, you even asked if we knew what was searched on the phone, and the fact of the matter is we don't. Opposing counsel
Doesn't the fact that they signed, that he signed 2 waivers, whether they were appropriately used by the principal, but doesn't the fact that he signed 2 waivers mean that there is a decreased expectation of privacy?
I see that my time has expired. May I
Please
answer
continue.
the question? Sure. There absolutely is a decreased expectation of privacy in these in this school environment. But as I was saying before, we don't know what was searched, so anything on a phone which can contain tons of information could have been searched, thereby violating the privacy interest of the student. Thank you.
Anything else you want to say?
Well, may I briefly conclude?
Yes, you can conclude.
Thank you.
I cut you off last time, so I'll let you conclude this time.
So, because the search was not justified in its inception, and because the search was not reasonably related in scope to the circumstances justifying the search, we respectfully request that this court reverse the decision of the 12th District.
Thank you. 3 judges or 7 or 9, Supreme Court. And to the right is the most senior, other than the presiding judge, and then left, it goes back and forth. So we're going to start with our 2 most junior justices. We'll go with Professor.
So I thought all 4 of you did an amazing job, and the distinctions we had to make in order to not have you all tied for me was hard. The one thing I would say as you're going forward, and you develop, and you should all be lawyers and all come to Ohio State. But one thing I wanted to see a little bit more from everyone was a little bit more of a theme. Whatever that theme is, I wanted to kind of see that theme as a thread that's throughout all of your arguments. So on the school side, perhaps the theme is you give up a little bit of rights for safe, effective education. This is par for the course. This search was completely reasonable and normal. And on the other side, maybe the theme is this is really special information. This has nothing to do with the school setting. And I saw some themes going back and forth. But when I used to argue for courts, before becoming a law professor, I would try to figure out what theme did I want that judge to have to go back and think about when the argument was over. And I saw some of that, but I would have loved to seen a lot more of each of those arguments coming back to some type of coherent theme of what you were trying to get the court to focus on as the key issue in the case.
I have a somewhat similar comment. So I still do this for a living, so I know what it's like to stand at the lectern there and be pushed around and have a tough thing to defend. So I sympathize with all of you. It's fun to play act on this side at least once a year. I thought you all did a great job knowing the nooks and crannies of this packet that's here, knowing the little variations and so forth. But I agree with the professor that I wrote it down as a home base or having more playing offense. I think of oral argument as you want to be playing offense as much as possible. It's hard when there's 7 people throwing questions at you. But the best way to do that is to have that theme or that base that you're trying to get back to, even if it's for 20 seconds or 3 seconds in between the questions. I think that's sort of the constructive comment that I would offer. But you all did a great job, and it's a pleasure to watch this, especially at your age.
Yeah, I think one of the hardest things to do as an advocate is have a conversation with the court, which is really what oral argument is, and you all were very comfortable looking up from whatever you had scripted or memorized and actually engaging with us, which is something that takes so long to develop, and the fact that you already are doing it in high school is amazing, so congratulations.
I'd echo that. The transitions between question and going back to your script was very good. My one point would be that answer the question directly first, yes, no, maybe, and then do the explanation instead of starting off with facts or this case law says blah, 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 blah. Give me the answer and then say why that answer is correct. But very good job. You guys should all be proud of yourselves.
I'm largely going to echo the sentiments of everyone that has come before. I think you all did an excellent job and are to be commended. I will note one stylistic thing that I thought everyone did well is sort of laying out your couple points at the beginning, because that is one of the first keys to getting a good theme, as Professor Walker was mentioning. And I know some of you even I noticed came back to that and laid down the marker at the beginning, and then you were able to come back to it. And that is a mark of in my opinion, a good advocate to be able to do that. And so, a lot of the things that we've told you here are things that we struggle with. Like some of the others still do this regularly, and so we're telling you these things that are hard for us to do at times. So, great job.
Yes, well done, everyone. I thought really terrific. I would offer a couple of stylistic critiques. Presence really matters a lot when you're arguing, and you don't want to go too fast. You don't want to do this gesture because it's like you're a teacher scolding the bench, and no one likes that. But just really terrific work, all of you.
Well, I guess I get to say a little bit more, not much. You guys are all excellent. I have argued in the 2nd Circuit in New York, and the 6th Circuit course in Cincinnati, and the 10th Circuit in Denver, and had a win in the U.S. Supreme Court. And you all will make great lawyers if that's what you decide to do. M1, great knowledge of the case. M2, persuasion. If you ever have a significant other, you're going to win a lot of arguments that I don't. H3, use of the cases, you were brilliant. Drayton, no, I'm not kidding. Drayton, Acton, pulling them up under that withering questioning, very good. H4, great use of reference to the principal's testimony. You referred directly to a part of the record. And normally in oral argument, the facts are pretty well known. But when you want to make a point and you can refer to it exactly, that impresses. Your professionalism style is wonderful. Even if you're not lawyers later on in life, what you're learning here will make a difference in your life. You're all smart, I can tell. That's cognitive ability. But non-cognitive ability, that is how to deal with people through emotional intelligence, is going to become more and more important in the age of electronics, because there's going to be less and less direct contact, but now with, let's call it video telephone, where you'll be seeing the person. Your ability to persuade and stand and give a presentation to a boss or to a whole group of people in offices throughout the globe will benefit you every day of your careers. It really will. And you should all be proud of your ability to stand there under, I can tell you, and if you go look on the Supreme Court website, I don't know if you've ever looked, but all the oral arguments are there. You will not see a more withering set of questions than what you saw here today. I'm not kidding you. Some of it may be more esoteric. I'm not saying that. But the continued artillery lobbing stuff in, and you all, every one of you handled it, and being able to speak on your feet will benefit you 1,000-fold as time goes on, no matter what you do. Very good. I guess we're waiting for the election results to come. Now, are we allowed to ask what year in high school you all are? Petitioners?
Juniors.
Juniors?
Yep.
Okay. Well, you got good features.
That's amazing.
Are we done? Okay. The other thing, I know today is probably a long day for y'all. Was it sixth, seventh time you've done this today? Yes. If you ever get a chance to come back to this building and take the tour of the architecture and history and art in this building and relax a little bit, but you will enjoy it. This is, there's one historian who has said that a building like this will never be built in Ohio again, and I believe it. It's just beautiful, and the architecture and art is.
All right, thank you so much. So at this time, we are going to release the rest of our justices, but we are so fortunate that Justice Fisher is going to stay to help us pass out awards. So with that said, all rise. Thank you, justices.
Thank you. Thank you so much.
Thank you.
Thank you so much. Thank you. Thank you. Thank you. Thank you. Thank you so much. Thank you. Thank you. Thank you.
All right.
Where do you want me?
Yeah, can you come?
Okay.
If you don't mind. Thank you. So I'm going to do quarterfinals, semifinalists, and then individual, and the winner. Okay. Perfect. All right, so for those teams that are still here, we would like to congratulate our quarterfinalists. So if we still have a representative from those teams, if you could come and get one of your plaques. Just kidding. Okay, one of our first quarterfinalists is Mason High School, which was Team E. Do we have anyone here from? Okay. Next, we have Team A, which was Gilmour, Team Brandon. And next, we have Springfield, Team Austin. And then we have Sycamore, which was Team B. Okay, and next we have our semifinalists. If we still have a representative here, come get your award. We have Danville High School, which was Team C. Okay, and then we have Indian Hill, which was Team J. All right, now we're going to do individual awards. We'll start with Best Advocate, the top 3 advocates for Petitioner. We have J1, which was Zhang Wang Ru with Indian Hill High School. Next, we have H1, Veda Krump from Springfield, Team Themis. And next we have J2, James Orr from Indian Hill High School. For Best Advocate Respondent, we have J3, Cameron Metz from Indian Hill High School. Next, we have H4, Helena Buckman from Springfield, Team Themis. Next, we have M3, Ray Zafar with Gilmour, Team D'Angelo. Okay, I know you guys were maybe wondering about this one. We are going to do the runner-up. If you could come up as a team and get your trophies, and if the advisor could come up and read the names of the students so that we can hand out individual medals, that would be great. The runner-up in this year's competition is Team H, Springfield Themis. Do you want to read off the names?
Sure. Here we have Veda Crumpy and Helena Buckman, along with our timekeeper, Maliha Umarani. Thank you.
Congratulations to Springfield High School, our runner-up. And without further ado, your championship winner this year, we have Team M, Gilmour Academy, Team D'Angelo.
we have Sabrina Ballman, Sebastian Williams, and Zachary Holt for Team D'Angelo from Gilmour Academy.
Thank you. Congratulations to Gilmour High School. And with that, that wraps up our, those are extras, I think, yeah. With that, that wraps up our 4th annual Moot Court competition. Thank you everyone for joining us for a long but productive day, and we will see you next year. Thank you.